Senator Garrett, you're in order for 2170.
Thank you, Mr. Chairman. The subcommittee report was signed again by myself and Senator Williams, and we recommend passage.
We recognize you for opening comments.
Thank you, Mr. Chairman. This again is a relatively simple bill in concept. I understand there's some controversy in connection with it, but what it has to do with free exercise of religion and putting some limits on what governments can do to burden or restrict your right of free exercise of religion. It says that a government shall not do any of the following. And there's just a few things here that it covers. Government shall not treat religious conduct more restrictively than comparable secular conduct because of alleged economic need or benefit. Shall not treat religious conduct more restrictively than any secular conduct of a reasonably comparable risk. Shall not substantially burden a person's exercise of religion unless applying the burden to the exercise of religion in a particular situation is essential to further a compelling governmental interest and is the least restrictive means of furthering that compelling government interest. And finally, it provides a person who has been damaged or burdened in violation of this bill can file an action for damages. And we all know how important the right to freedom of religion is. It's one of our, in fact, in our first amendment to our U.S. Constitution, and it's embedded in our society. And Mr. Chairman, those are my opening remarks.
Chair recognizes Senator Hope.
Thank you, Mr. Chair. I would encourage the committee, as I've done in past years, to oppose this legislation. I think this is the fourth or fifth time we've seen it over the last 6 years. And I would just have two comments in the interest of time. Number one, this bill is opposed by a long list of business and other organizations that are important to our state, including the Iowa Chamber Alliance, the Council Bluffs Chamber of Commerce, the Cedar Rapids Metro Economic Alliance, the Iowa Business Council, the Greater Des Moines Partnership, along with One Iowa, the Interfaith Alliance, the Coalition Against Domestic Violence, and the ACLU. And they largely oppose it for fear that this bill is being used as a vehicle to enable discrimination against people based on sexual orientation or race or other reasons. The second thing I want to share with the committee is there's been some criticism that the courts haven't done this. Well, the courts do protect the exercise of free religion. However, as Justice Scalia explained in the 1990 decision of Employment Division versus Smith, we have never held that an individual's religious beliefs excuse him from compliance with an otherwise valid law prohibiting conduct that the state is free to regulate. On the contrary, the record of more than a century of our free exercise jurisprudence contradicts that proposition. As described succinctly by Justice Frankfurter, conscientious scruples have not, in the course of the long struggle for religious toleration, relieved the individual from obedience to a general law not aimed at the promotion or restriction of religious beliefs. The mere possession of religious convictions which contradict the relevant concerns of a political society does not relieve the citizen from the discharge of political responsibilities. We first had occasion to assert that principle in Reynolds versus United States in 1879, where we rejected the claim that criminal laws against polygamy could not be constitutionally applied to those whose religion commanded the practice. Laws, we said, are made for the government of actions, and while they cannot interfere with mere religious belief and opinions, they may with practices. Can a man excuse his practices to the contrary because of his religious belief? To permit this would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. Justice Scalia goes on to explain why the compelling interest test is problematic. If compelling interest really means what it says, and watering it down here would subvert its rigor in the other fields where it is applied, many laws will not meet the test. Any society adopting such a system would be courting anarchy, but that danger increases in direct proportion to the society's diversity of religious beliefs and its determination to coerce or suppress none of them. Precisely because we are a cosmopolitan nation made up of people of almost every conceivable religious preference, and precisely because we value and protect that religious divergence, we cannot afford the luxury of deeming presumptively invalid, as applied to the religious objector, every regulation of conduct that does not protect an interest of the highest order. The rule respondents favor would open the prospect of constitutionally required religious exemptions from civic obligations of almost every kind, ranging from compulsory military service to the payment of taxes, to health and safety regulations such as manslaughter and child neglect laws, compulsory vaccination laws, drug laws, and traffic laws, to social welfare legislation such as minimum wage laws, child labor laws, animal cruelty laws, environmental protection laws, and laws providing for equality of opportunity for the races. Justice Scalia concludes the First Amendment's protection of religious liberty does not require this. I really do just encourage you to think about what you're doing with this legislation. You have something in mind that I don't think reflects the diversity of religious practices in our state or our country. The one thing we know is if you vote for this, you will be voting to legalize the use of peyote in religious practices. Maybe that's something you campaigned on. Maybe that's something you believe. But we know that because that was the case of Employment Division versus Smith, that after the federal counterpart of this was passed, the court held, no, we can't prohibit peyote use for religious practice anymore. So that is the one case we know would affect Iowa on that. But you also have the other laws that we talked about here, from polygamy to compulsory military service to health and safety regulations such as child neglect laws, animal cruelty laws, child labor laws, and equality of opportunity for the races and civil rights laws. So I do think this is the wrong direction to go. I'm going to vote with Justice Scalia from 1990 and say we shouldn't go down the compelling interest test here in this bill, and I'd encourage the rest of the committee to vote no. Thank you, Mr. Chair.
Any other discussion on Senate File 2170? Senator Guth.
Thank you, Mr. Chair. And thank you, Senator Hogue, for adding the date on Justice Scalia's comments there. I would just like to mention that since 1990, when he made those comments, there hasn't been that type of a problem happen. We've had this as a federal law since that time, and it's currently the law in 31 states across our country. It's not been a problem. Thank you very much.
Agreed. I think most people just want to be able to go to church and exercise their religion. The First Amendment, we all think, gives us that right to do, and yet we saw in California and the state of Illinois, governors shutting down churches while keeping other businesses open, and we're going to stop that. It's unfortunate to me that we even have to have this type of a bill before the Iowa Senate here, and because we should be able to rely on our constitutional rights for freedom of religion, and apparently we can't do that. 31 other states and the federal government also have this law, and I don't see a problem with it. I'm going to pass it. Thank you. thanks for the opportunity to pass it.
Senator Garrett, you're in order for closing comments.
Thank you, Mr. Chairman. Well, thank you, Senator Hogue. I listened with interest to your description of, I guess, what you think this bill says, and you made it sound awfully extreme. The only thing is, the way I read this bill, it doesn't do the things that you claim it does. Let's look again here. Exactly what does the bill say? You can't treat religious conduct more restrictively than comparable secular conduct. It doesn't say you can eliminate secular conduct if you have a claim of a religious principle. It says you can't treat religion more restrictively. Section B, you can't treat religious conduct more restrictively than secular conduct of a reasonable comparable risk. Doesn't say religion trumps or eliminates secular conduct. It just says you can't be more harsh on religious conduct than on secular conduct of a reasonable comparable risk. C, you can't substantially burden a person's exercise of religion, fundamental constitutional right, unless applying the burden to that person's exercise of religion in a particular situation is essential to further a compelling governmental interest. So if it's essential to compelling a fundamental governmental interest, bill doesn't say you can't burden religion. And it goes on to say, under those circumstances, whatever burden or limitation you're putting on religion has to be the least restrictive means of furthering that compelling governmental interest. Now, what's so awful about that? That's an altogether different standard than what we heard from Senator Hogue just a little bit ago. Also, as several of my compatriots here have said, a number of other states have very similar laws. The federal government has had very similar law for many, many, many years. And all these things that Senator Hogue was talking about, for some reason, they haven't happened. Doesn't that mean anything? Our experience contradicts the predictions that Senator Hogue was making. Are things going to be different here in Iowa than in all these other states? Are we going to do the kinds of things he says rather than implement and enforce the law as it's written, as I've explained it here? So I think it's a very reasonable bill. It corrects an error that we saw and has also been mentioned, where religious activities were treated more harshly, not equally, more harshly than secular activities. So I would ask my fellow senators on the local government committee here to approve this bill, and let's send it on to the floor, and let's legally protect our fellow citizens in their exercise of their religious rights, their constitutional religious rights. So those are my final comments, Mr. Chairman.
Thank you, Senator Garrett. A record roll call vote has been requested, so the Secretary will please call the roll.
Senator Shipley?
Aye.
Senator Clemish?
Aye. Senator Clemish votes aye.
Senator Smith? No.
Senator Smith votes no.
Senator Driscoll? Aye.
Senator Driscoll votes aye.
Senator Garrett? Aye.
Senator Garrett votes aye.
Senator
Senator Guth votes aye.
No.
Senator Hoag votes no. Senator Lofgren votes aye.
No.
Senator Quirmbach votes no. Senator Taylor votes no. Senator Williams votes aye. Okay, I appreciate your enthusiasm, however. Senate File 2170 passes out of committee and moves on to the floor. We recognize Senator Clemish for Senate File 2153.
Thank you, Mr. Chairman. Your